Court of Appeals, Division 1 is now in session.
Morning, please be seated. All right, we are here for oral argument in CV 22-0395, workers at all v. City of Tempe et al. You may have noticed that the clocks look differently than usual. They are currently set to 10 minutes apiece. We as a panel discussed this and decided we'd like to sort of take up the appeal and the cross appeals separately. So as we currently have it framed, we anticipate that Mr. Barton will start us off on strict compliance. Mr. Artigue will then respond, and then if you have reserved any time for rebuttal of that 10 minutes, you'll have that opportunity. Then we'll take a beat, reset the clocks to 10 minutes, and we'll do the reverse, starting off with Ms. Ankers, followed by Mr. Barton, and then if you have reserved time for rebuttal. Now, we're not opposed if you would like to, I know you've joined arguments, and if you want to split any time, but that's going to be up to you within those confines. Do you have any questions about that setup? Great. All of this, of course, is subject to the discretion of the panel to add time if we decide there are things that we would like to continue talking about. But at the moment, this is the plan. Keep in mind, we have read the briefing. We discussed the case this morning. We reviewed the record. And with that, Mr. Barton, if you'd like to kick us off.
Good morning. May it please the court. My name is Jim Barton with Barton Mendez Soto, and I'm here on behalf of the workers in this case. Both these issues do have a through line, which is they both deal with limitations on the power of the government, particularly as constrained by the referendum authority granted in the Constitution and under Title 19 of the statutes. This first issue that we're talking about has to do with the committee using the form that was provided by the city and whether or not that strictly complied with the Constitution and Title 19. Our position is that it did, and I think I would like to really urge the court to decide this on the statute, because it's very important. If you look at strict compliance, what it says is, it says that it's strict compliance with the requirements of the Constitution and the statutes in Arizona. And that really means that we need to look to stated requirements that are explicit in the statutes and not find new requirements that are implied or perhaps suggested by the statutes. So I think that the easiest way to dispose of this case is to simply look at 19-101, where it identifies what needs to be on the petition. Importantly, some components of 19-101 explicitly state where they need to be, right? So 19-101B provides that you have to say it is unlawful to sign this petition before it has a serial number. Well, those words need to be at the top of each sheet. C talks about paid circulator versus volunteered. Those not only have to be at the top, but they have to be at the top right. Furthermore, they have to be in 12-point font. They have to be bold. Lots of direction on where you put those items. The serial number itself, although it's not in 101, it is in 121, that says a serial number has to be on the bottom right. So we have examples in the statute. The legislature knows how to tell municipalities and citizens where to put things in the petition, and they did it in some places.
In 19-101A, I think it's 8, yeah, where it says the following shall be the form for referring to the people, and then it lists things in orders. Why don't we take that to mean the form requires this ordering of these issues?
Well, thank you, Your Honor. You shouldn't take it that way because it doesn't say it has to be in this order, and I just gave you other examples of where it did say what order they had to be in. And frankly, the city, for whatever reason, rearranged the form to move the petition for referendum above the referendum description. We don't know for sure why the city did that, but the city had no guidance. The city has no guidance in A that says that one has to come before the other. I want to distinguish this from the rifle case.
The signature lines were first. Like the form just began with, well, except for where C says it has to be top right. If it went top right, the C requirement, and then had signature lines and then the description and the thing at the bottom, wouldn't we have a problem then?
You would not have a problem. And the reason you would not have a problem is because the statute doesn't require the signature lines to be in any particular space. And in fact, in the Van Riper case, they did 10 lines instead of 15. Now, the court in Van Riper looked at what the Secretary of State looks at when in 12101 they review, or in that case, whoever the elected official was, and said that they will strike more than 15 signatures, right? But the form of the petition, as described in 19101, says 15 lines. In Van Riper, they had 10. The court said, no, we're not going to say that doesn't strictly comply. Once again, if you put the signature, I agree it would be peculiar. I don't know why they would do that. I think that would make the form look odd, but it doesn't.
Would there be an argument about, sort of notice or misleading? So if you had the signature lines up front, somebody is, at least in theory, signing before they've read or instead of reading what's on the petition. So wouldn't there be some argument in that realm if the signature lines were reversed?
I think there could be some argument about that. And this is a good example of where the court goes if the court doesn't stay strictly to what is written in the statute and doesn't adhere to requirements that are written in the statute. There could be an argument that it should be that you have to have this top matter first and then the signatures. But it doesn't say that. And in fact, it does say where other things are supposed to be. And when we're talking about a citizen's fundamental right to referendum, I think we cannot strike petitions where, again, we're adhering to the form that the government provided us, and there's no language in this statute that would have told the city of Tempe that they couldn't do the form that way.
What do you make of D and E? That in D, the legislature said, or the statute says, that these things have to be checked, and in E, it says specifically, if they aren't checked, here's what happens. Does that inform our decision or our analysis at all?
I think it does in as much as it shows how the legislature needs to be clear with the requirements. If we're going to strike 15 signatures, we're going to say 15 citizen signatures, nope, you are unable to petition your government because of this rule, it needs to be explicit. And in E, they've made it explicit that if you don't mark those boxes, and importantly in E, you have to mark the boxes first. So this isn't a thing you can go fix after the fact, right? Because that would not be fair, that wouldn't make sense. The signer needs to know who's paid or volunteer. So I think that's what you make of E, that these requirements have to be this way. I want to turn the court's attention to the supplemental authority we gave you in Libson v. Hobbs. That was this recent ballot measure case. And you had a situation there where the Secretary of State had a way to do business. The opponents of the initiative process said the way the Secretary of State was registering circulators was unconstitutional. The Supreme Court agreed with the challengers in that case and said, yep.
The Supreme Court also found that it was impossible to comply. You're not arguing that it would be impossible for you guys to have made your own form and changed the order to follow the statutory suggestion.
Well, it would be, I am arguing that. It would be unreasonable for us to reject the form that is provided by the government.
Different than impossible.
That's right, Your Honor, but the
you
court
don't have a printer or the ability to change your form.
Your Honor, the court addressed exactly this in the Libson case. They said they could have mailed the forms to the Secretary of State, but there's no reason to believe that the Secretary of State would have accepted them. And this court said that is too high of a burden. It said it would unreasonably hinder or restrict the committee and the people's constitutional guarantee to the right of initiative to ask them to make up their own process and to sort of mail the forms in. In this case, we use the form that the city provided, as is required. We laid out in the brief how the elections
official... What's your authority that says the city requires you to use this form? They provided it. Is there some statute or ordinance that says the city says we'll only take this form?
There is a statute that says that if you rely on the form that is provided by the elections official, it's presumed to strictly comply.
No, there's a statute that says that in initiatives, not in referendum. My question was, is there an ordinance or statute that says the city will only accept ones that follow their specific form?
There is no ordinance that says that. However, what you have a situation that you're setting up, and this is the situation that they talked about in Libson, is this trap that would be laid for the committee of where, here's the form that's provided by the city. And I do want to point out that, yes, Your Honor, the section that talks about the presumption that the form will strictly comply, that is specifically under the initiative section. However, under 19, 102, it's clear that the form of petition for the initiative and the form of petition for referendum are the same, except for where it's distinguished. And that's ARS 19102A. The form of the petition for a law or amendment of the Constitution of the state or county, et cetera, so on, shall be substantially in the form prescribed by 19101.
But that again says initiative. Where are you saying that?
It says that it shall be in substantially the same form as 19101, and 19101 is the form for referendum. So 102 itself links the two types, the forms of initiative and referendum. In any
If you
case,
want to reserve any time for rebuttal on this issue, you probably should now.
all right, I will. With that recommendation, I'll reserve my 1 minute for rebuttal.
Good morning. My name is Cameron Artigue on behalf of South Pier Tempe Development. The court's order setting oral argument directed the parties to the meaning of the word form, and I'd like to pick up with your question, Judge Perkins. Form connotes organization. Form connotes structure, not just a list of ingredients.
What's your authority for that?
The word, Webster's Dictionary.
Really? Because I saw 25 or more different definitions of the word form in Webster's. So
Well, the
which one are you
first
citing?
definition in Webster's is shape and structure as distinguished from material. I would suggest, Your Honor, the form of a bundt cake is not flour, eggs, and sugar. The form of a sonnet is not 140 words on a page. And when the legislature says the following shall
So
be
when
the
there's
form,
25 plus different definitions of the word form, we are supposed to define which one the legislature intended? Or do we look at the context of the statute in the entirety of the entire election statute?
Oh, I think the latter, Your Honor, and that's why we win. The context here is 101 says this shall be the form. The initiative statute, 102, says the following shall be substantially the form. Same for the nominating petition, same for the recall petition. The referendum statute is the only one that says shall be the form without modification, and that is amplified by 19101.01, which says uniquely with respect to referenda, any slip is fatal. Strict compliance is required. So you have the judicial...
Those are two different concepts. Strict compliance, in your definition, is any slip is fatal?
I'm saying when the legislature says the form is A then B...
Where does the legislature or any of our case law say any slip is fatal for strict compliance?
I'm paraphrasing 19101.01, Your Honor.
Okay.
Where it says that the legislature specifies that strict compliance is required.
Okay. Let me ask you a question then.
Sure.
So this form, they says shall be the form. Let's say that they had not used their printers and word processing software and had taken the form and added Spanish language translations next to. So they had a block here that says here's the description and next to it a Spanish language translation. Would that be fatal?
I think so. It does not follow the form. Yeah, you
so-
couldn't rearrange the content in a trial subpoena. You can't put the caption at the bottom and put the ADA notice at the top and bury the here is when you must appear
So then why
somewhere in the
did the
middle.
legislature specify in C where they want stuff specifically, or B and C where they want stuff specifically at the top and top right, but not do that with respect to the order?
Because those subsections predate 19101.01, which was enacted in 2015.
It was enacted in 2015, but all it did was apply, or tell me if I'm wrong, that had been the law since at least the 1980s that strict compliance applied in referendum.
Strict compliance has been required always. There is case law. There's at least one case since Western DevCorps in 1991. There's at least one case out there that says, well...
I think it cites a 1980 case, it cites a 1925 case, so...
Fair enough, Your Honor. I only go back to 1991. But there is an old case that says, well, gosh, the legislature didn't specify that this error is fatal. And after that, the legislature enacts a special statute that says, hey, with respect to referenda, strict compliance is required.
But it was, our case law already said that.
Indeed, it did.
Okay.
Indeed. So you have both branches of government saying any slip is fatal. Let me turn to the supplemental authority.
I will take issue again.
Okay, you're right. I am admonished not to paraphrase, but you have both branches of government saying strict compliance is required. Let me just...
So the legislature, let me again push you on this point. So you say if they provided a Spanish language translation, they would have to reject the form. Even if it had all the other required information in the order that it's listed, but you put a Spanish language translation on that page, it's...
Yeah, for one thing, it wouldn't, yes, it would not fit the form. You couldn't put it in Spanish. You couldn't put it in you know...
What if the font size is too big or too little?
That does not comply.
So in one section, they specify specifically the font. But I presume that when the legislature printed the statute, it came out in, let's say, 13-point font. Do they have to comply with 13-point
Yes.
font? Because that's, even though it doesn't say anywhere what font the form shall be printed.
It does. It says the text has to be an 8-point font.
No, it only says that, it does say an 8-point
Yes.
font? Where?
I don't have the text must be an 8-point font. The page circulator and volunteer specification must be in at least 12-point font. The 8-point is, I think it's...
That's what I was referring to.
Okay.
8-point font.
But the text itself must be an 8-point font. If you put it in 6-point font, it's a defective petition.
Well,
it has to be so.
I appreciate
Because this whole business of, is it good enough? Is it will people be misled? That's the world of substantial compliance. Those determinations are what substantial compliance...
You mean strict?
No, substantial. When the court is saying, is this good enough, that's substantial. That's what you would do with an initiative petition. With a referendum, you don't go there. You just say, does it comply with the statute? And if it doesn't, then it's defective.
If it's 10-point font, it's defective.
If it needs to be in 12, if the legislature said it must be 12, and it's in 10, it's defective.
What if it's larger?
Oh, well, that's what the legislature said at least. So it can be larger.
Okay.
The supplemental authority they cite you
Where
to...
is it? I'm sorry, and I'm exposing my ignorance here and using your time, but I see the 12-point font in 101. Where is the 8-point font?
The 8-point type requirement, Your Honor, I don't have that citation at hand. I know it's in the statutes. I know the text of the measure to be referred must appear in at least 8-point type.
Okay.
It's in these statutes. I could be happy to supply the court with that after. The Liebson versus Hobbs case that the Supreme Court decided less than a month ago says in paragraph 25 that it is an excuse when the Secretary of State makes it impossible to comply. But the Supreme Court says the committee did not merely rely on bad advice from the Secretary's office, which would not have excused noncompliance. And what case does the Supreme Court cite? Western DevCorps versus City of Scottsdale, the case we cited, where the circulators relied upon the form given to them by the Scottsdale city clerk. And said, gosh, we used the city's form that they gave us, and the Supreme Court says...
assume that generally cities don't like referenda?
I have no basis to make that assumption.
Well, but it's, the city voted as a city council to do something. Why wouldn't every city just provide faulty forms going forward? And it's up to the people challenging the referenda to figure it out and do their own.
Your Honor, I guess I would presume that city clerks do their jobs responsibly, but more importantly, that's all the more reason why it is on the proponents to get it right. Because the city clerk is not their lawyer.
Liebson said, we're doing this one time because the Secretary of State screwed up. At least implied, if not explicit in that decision, is we're not going to do this again.
In the Supreme Court's decision?
Yeah. We'll make a one-time exception because
I think the Supreme Court's decision said it is an excuse when it is rendered impossible. And Judge Morse, your question to opposing counsel, where is the evidence that compliance was impossible? The answer is there is none. There's no such allegation in this case. The city clerk handed them a defective form and they ran with it. Yeah. And Western DevCorps says that doesn't matter. It's on them to get it right. And they didn't.
And I realize I've been throwing you off, and I apologize for that. You've done a great job in handling tough questions up here. But let's go back to form for just a second. Would you agree that really the definition of form is kind of what this whole case turns on?
Yes. And form is not a list of ingredients. Form connotes structure and sequence. I know there's 25 definitions in Webster's,
Well,
but
I
the
could be wrong.
pertinent one here, as I said, in the form of a subpoena, you can't just say, well, I'm going to subpoena this guy, but I don't really want him to show up, so I'm just going to mix it around.
What do we take of it
you
then?
know,
What do we take of it then that in other sections, the legislature where there's been a form has said specifically, and don't modify this form?
I think that's belt and suspenders. I think that when the legislature says...
When they say, use this form and don't change it in other sections, but they say, here's the form in this section.
No, you're imputing...
Imply that silence?
You're using an expressio unius argument to overturn the judicial requirement of strict compliance, and you're using expressio unius to repeal 19101.01. In a limited context, your argument would have force. It doesn't here.
And I'm going to exercise my discretion to just ask you
Sure.
another question then. The Division 2 case that found the signature lines, you think that's just wrong then?
The extra signature lines?
Yes.
Oh, no, yeah, I think 15 is the max per the statute. If you have 10...
No, I mean, if you read 101, it says 15 signature lines which shall be numbered. It doesn't say max. There's a max section later that Division 2 relied on to say, well, since it tells the Secretary of State not to count it if there's more than 15, we think that it means 101 also is a max.
Well, I'm not sure what your question is, Your Honor. I mean, you
Division
can't...
2 said the fact that the form had 10 lines instead of 15 does not violate strict compliance.
Oh, I think that you have to harmonize the statute. If the form shows 10 and the text of the statute says 15, I think that statute is harmonized. You know, the intent of the legislature
So
is 15.
you're not saying that Division 2 is wrong?
I'm not saying Division 2 is wrong.
Okay.
Thank you.
The issue about font is the title and text that's attached has to be at least 8 points. That's where you'll find it, and it's in another section. I don't have the site either, but it's the title and text. So here's a picture of as I printed off the statute. There's a font size for the rest of these words. These words for page or survey, they have to be 12-point font. That's required by statute. The rest of this, I don't know what font it's in, and I guess I could figure it out and check it against the copy that was provided by the city, but that's not necessary. We don't need to. The form means the content that is provided. That's what Western DevCorps said, by the way. They said you can't just go by the format. It's not format. Form means the content of what is required by the statute and the Constitution. And that's why Western DevCorps had a problem when they did not identify the content was wrong. They didn't say who was qualified to sign the petition. Rifle is about the content. It says in the statute, insert this description. Rifle didn't insert it. They attached it. They violated the form because they didn't include the content that was required by the statute. And I urge the court to limit the limitation on the citizen's right to only what is explicit and written in the statute.
Thank you, counsel.
Thank you.
We'll give just a moment for the bailiff to reset the clocks both to 10.
Sorry, I'm sitting here just staring.
I know, we're riveted by the clocks.
Reminds me when I used to put gas in. You have to get it to exactly $10 because that's all you had, and those last two cents were very difficult.
All right, with that, Ms. Anchors.
Okay. Good morning, Your Honors. May it please the Court, Sarah Anchors on behalf of the City of Tempe. Just want to note briefly, we were talking about 8-point font before, and it was an ARS 19-112. As a reference to 8-point font.
Thank you.
But that's not part of my argument. As Mr. Artigue has already addressed the form argument, the city urges the court to find that statute does not dictate that all development agreements are referable. The power of voters to use referendum is an extraordinary power, and courts require strict compliance to ensure that constitutional right of referendum is not abused or improperly expanded. And in workers' argument that statute dictates that all development agreements are referable is doing just that. It's improperly attempting to expand the application of the referendum power. Looking at the plain language of 9...
Why did the legislature specify that development agreements can't be effective for 30 days?
So the addition in 500.05G that it had to be, that development agreements are not effective until 30 days, that the legislature did not say, there's not been evidence in this case to say exactly why the legislature enacted that. I mean, certainly it'd be odd for a development agreement to be an emergency measure. I don't see it in looking at the restrictions for what is an emergency, for immediate preservation of peace, health, or safety of the city or town, how a development agreement could ever meet that. And certainly it is possible that a development agreement could have provisions in it that make it referable. It could have zoning provisions. It could make permanent changes to the land or commitment to change the zoning on the property or commitment to...
What exactly did the development agreement do in here? And the record is fulsome, but let's make sure I know exactly what it did. It set up the GIPLET, right?
Correct.
Okay. It provided for the sale of some of the land?
Right. Well, it provided for that there are some city parcels and there's some parcels owned by South Pier, and that together those parcels would be put together to make this South Pier development. And that
So the city's
would be
disposing
used.
of land that it owns in the development agreement?
And so, right, that there would be, together with the lease operation of the GIPLET.
Why wouldn't that, just by itself, sale of land, be referable but to the voters? Let's say the city of Tempe has 100 acres, wants to put that up for sale, and they're going to sell it. I mean, for whatever reason, legislative or administrative, and why?
So that would be, I mean, that is the city's disposition of its own property, and there's not been any case law saying that is a legislative decision. It's not changing the character of the land in terms of changing the zoning, changing what could be put on the land.
But it's pretty permanent.
Well,
I mean, if the town, unless the town's going to turn around and condemn it back, but I mean, it's permanent.
well, that all sales are permanent, but it's not a policy in terms of selling land. I mean,
do they go around selling land often?
I have no idea how often cities in Arizona go around selling land. I mean, certainly they do at times.
I mean, who does it
it's
take
that
to
common.
set? Who does it tell? Who has to authorize the sale of property? The city manager? Can the city manager?
The city
sign it?
council. The city council under Tempe code.
So it seems like, okay, it's a pretty formal process.
To dispose of land?
Yes.
Yeah, I mean, the city has to dispose of it in a way that doesn't violate the gift clause, right? I mean, it has to get fair market value for the land. It's not, but I don't see it as that as part of a policy. I mean, it would be one thing if the city had, this is going to be our, implementing a policy that we're going to raise revenue by buying and selling land, like we're getting into the real estate business. I mean, I think that would be a policy, but I don't see
So whether or not it's a policy, is that the sort of the overriding factor across all? So we look to permanence, we look to specific versus general, but are you saying that regardless of the permanence factor, the sort of, is it a policy or is it a new policy, would override that factor? Or how do we work with these different factors in the facts of this?
Well, I think that Wennerstrom dictates that we look at multiple factors. We look kind of like at the gestalt of what is being done here. And so permanent in general, does it make new law, new policy? Is it a new plan? Is it declaring a public purpose and making ways and means to accomplish, and there's making ways and means to accomplish that purpose?
What if the factors are competing? What if you have a 2-1 split? Is there any case law that addresses what you do there? Because most of the case I've seen generally finds that all three factors tend one way or lean one way, and then and it makes the decision easy. What if there's a clear split?
Yeah, and I mean, there isn't an exact accounting that I've seen courts use, a balance, saying this factor is like the overriding factor that we look at. But I think that it is, in terms of looking at the big picture of what the challenged measure does, in terms of is this legislation that's declaring a public purpose and a policy, or is this something that is being done by the city pursuant to its already declared public purposes and policies, such as here, the land had already been declared, it was already MU4 zoning, there's already this mixed-use zoning, and there's specific provisions of the zoning code that address what can be put on that property and how it could be put on that
Understood,
property.
but how does that relate to, how does that, you make the connection there to selling property, leasing property, doing a sales tax rebate, I understand? Isn't there also a sales tax component here?
There's a sales tax component to it as well.
And how did in Fritz, I think the court, Supreme Court talked about having the citizens have the opportunity to know what their public, their elected officials are doing. How did your average citizen know, oh, MU4 zoning, yeah, that means that you can do sales tax rebates, the GIPLET leases, you can do, you can sell property. That seems pretty broad to me.
So, in order for a property in order for there to be a property that's used for GIPLET, it has to be declared a redevelopment area. So that's under 361473 and 361472. So it has to be declared that the area is slum or blighted.
Understood. Does that flow directly from the zoning? It does not. That's an extra step, right?
That's a second, right, that's a
Okay.
different step. And that has to be in the, I think it was.
The GIPLET, I think what he's getting at is the GIPLET was not automatic as a result of the MU zoning designation.
No.
So why isn't that alone enough to make this referable?
Why isn't what alone? I'm
The
sorry.
fact that the GIPLET is contained in the development agreement.
Because that's a lease, that's a tax mechanism, and it's a lease of the property. I mean, it's
But
a
it's a tax mechanism, and it's taking
Correct.
money from the city coffers. Obviously, the city thinks it's getting far more in return, but why isn't that, I mean, that's tax policy.
But that's,
Are you arguing
that's
that it's
use.
not tax policy to determine where sales tax go?
That's, I mean, that is, no, I'm not arguing that. I mean, it's use of city revenues, and every use of city revenues is not necessarily referable.
Well, it's different to say once revenues have come in and become part of the general fund, and then how the city spends them versus, well, actually, those probably would. If it's part of the budget could be referable, but even assuming it's not, to say we're going to take certain money out of the general fund and give it back to the developer, isn't that a policy decision?
Well, I mean, it had already been allowed that, I mean, GIPLETs are allowed,
Yeah,
wanted
GIPLETs
to
are
reserve
clearly
some
allowed,
time.
but the question is, are they referable?
it's not been argued here that it's referable, and I don't believe they would be.
Well, they argued the development agreement, and part of what they argue is the development agreement is referable because it contains a GIPLET. And I don't know if I'm pronouncing that correctly, GIPLET or not.
That's the word
And
I use
I
as
know that
well.
I've been pushing her on this, and she asked to reserve time at about 1 minute, so I would like to give her an additional minute since I'm taking all of her time.
Thank you. I mean, the GIPLET is not, it's not a new policy, it's not dictation of a new policy that the city is going to be using. The city already uses GIPLETs, and the legislature has allowed the city to use GIPLETs once a property has been declared to meet the requirements such that a GIPLET could be used. And so the fact that it's going to use this mechanism, this ways and means, is not a new policy that the city is adopting.
Okay, thank you, counsel. If you'd add 1 minute for rebuttal, do you want to give?
Yeah, and I think,
And then make the other side 11. Perfect. Well done.
Thank you. You know, the trial court did not, wasn't impressed with our argument that subsection G settles this matter, but I have to tell you that I really have looked at it, I really believe it does. I don't understand any way that the legislature could say, okay, we're going to give you this power, you can do these deals, these public-private partnerships, and you can attract big businesses, and you can do these things, but notwithstanding 142B, you cannot pass these with an emergency measure. Well, 19142B is the whole point of that is referring measures and saying you can avoid a referral if you pass it with an emergency measure. So I don't understand how the legislature could have said you can't use an emergency measure without meaning that they understood it was subject to referendum. So I think this is.
Aren't there potential other explanations for the 30-day delay?
Yes, Your Honor. If it
I
said,
can't come up with one off the top of my head, but it seems like there could be other reasons to say we got to delay these for 30 days.
Your Honor, if it only said you must delay these 30 days, you can't make them immediately enforceable or something, that would be fine. That would be a more interesting argument. But in this case, it doesn't say that. It actually says, it specifically says, notwithstanding 19142B. So it's actually pointing us right there. And we did cite the legislative history, if you'd like to connect the dots on that, in our briefing, where they specifically said, we're putting this in here, and they talked about how, emergency clause would exempt them from a referendum. Nonetheless, the court below did an analysis of this particular agreement. I think that analysis is strong, and I think it upholds a scrutiny here. This is a very complex plan. This is the plan that creates the policy that is then enacted. The fact that the zoning is present does not put the citizenry on notice that this is what's going to happen. That's kind of the difference with the Reynoldsburger.
Before getting too far into this agreement, just thinking about sort of your initial argument under subsection G, is it then your position that all such development agreements are referable absent some sort of unusual characteristic that would take it out? So in other words, we would assume going in as a court that a development agreement under these statutes with the city is referable unless the city can show something unique about the character of this particular agreement that is not referable.
Yes, Your Honor. I think that when the legislature said you cannot use the emergency clause to get out from referring development agreements, specifically development agreements in the statute, when they said that, they made it clear that they are subject to, they're like kind of super subject to referral. They're not only subject to referral, you can't get out of it with an emergency clause.
Okay, thank you.
I was just going to reference that in Reynoldsburger, you had an example of where someone was building got a temporary or a conditional use permit to build a storage. In that case, perhaps the zoning was sufficient to put them on notice that that's the kind of thing that might happen. In the Mesa case in Reynoldsburger, you had an example of where the citizens had already passed the global plan, and then this was just enacting the global plan that had already been passed. We have neither of those two things here. One, we don't have a large prior plan that was passed that's just being enacted. This is the big plan. And two, it's not something you could just look at the zoning and understand that it would happen. And so I think if you look at those two cases at kind of different ways they've done the analysis, this is not either one of those. And so I think the court's analysis holds up.
What specifically in the development agreement gives you, what are your strongest points? Because it can't just be, it's complicated. It's complicated, it's 29 pages or how many ever pages, and it runs with the land, and it's going to be binding on successors. I mean, a lot of development agreements are going to fall into that category, perhaps. But what about this one specifically, in your mind, makes it particularly subject to referendum?
I was in the Navy, and we talk about boats and ships have boats. So, it's a ship if it has a boat, okay? This has boats, right? This has so many subparts to it. We talked about it. It's disposing of land. It is. It's establishing. It's envisioning a GIPLET. It's not the GIPLET. It's envisioning the GIPLET may happen down the road. It talks about all of these different. Public housing is going to benefit from this. It talks about specifically and permanently developing a particular parcel, many parcels of land. I think what makes this. And of course, my initial position is.
Let me jump in there for a second, because part of me wonders if this isn't premature. Because there's still a bunch of things that have to go on here. Like this is a PAD, if I understand, going way back to my old zoning days, but the PAD overlay here, correct? There's a PAD overlay, and that has to be all approved by the P&Z again, city council. It has to go through all the bells, jump through all the hoops. Okay, so do we really have a plan here? I mean, because they still have to do a lot of things. The GIPLET has to go through the process. There's still other things that, it seems like there's a lot of, here's what can happen if both sides live up to their agreement.
If we didn't have Warnerstrom, that would be, I think, a tougher position for me. But unfortunately, I mean, Warnerstrom makes it pretty clear that, the time to refer, or the time for citizen action, was when the big global plan was being, not when the individual implementations were. And so these implementations you're talking about, I think that would fall under, well, now that's administrative, that's no longer legislative.
Isn't that the city's argument now, is that your time to challenge this was when MU4 was passed? And now Judge Brown is saying, well, it's not even this, it's going to be later on.
Yeah.
I mean, at some point there has to be a decision that this is a policy/strategic kind of decision that you have to be able to refer, right? It can't be forever.
Well, I'm going to sound a little bit like a broken record and say the policy decision was when the legislature enacted subsection G, which made it clear. But, I think that's right. The argument is that the zoning ordinance was the thing that we should have referred, but we can't have referred the zoning ordinance because the zoning ordinance does not put us on notice to know that that there's going to be a giblet and there's going to be a sales tax issue and there's going to be land is going to be, I mean, that just wasn't there. That was the case in Reynoldsburger where they said, look, we zoned it, you knew the conditional use permit was coming. It's too late now. So that's all I have in the...
Why do, and maybe this is a question I'll direct towards your opponent when she comes back, but what is the benefit? Why do they enter into development agreements as opposed to just a contract or other type of agreement? Why designate it a development agreement?
I think that I suppose the city is in a better position to answer that, but the answer is because they provide these permanent changes. They provide these set, you get rid of the squishiness of having to worry about things change when a new political regime comes in. Because they're such permanent and stable is the word I was looking for, because they're such stable agreements, that's why they're interested in that. And we cited some cases in the brief I don't have right here.
It's even more than just a ordinance. I mean, because it prevents future city councils from changing that ordinance.
Yes,
so
Your
it's
Honor.
like super statute, right?
I agree, it's a super statute.
Which, wouldn't that favor even more making it referable? And boy, what a softball I couldn't have.
Yes, Your Honor, I agree.
Thank you.
Thank you.
In terms of section 500.05, it dictating that all development agreements are referable, I mean, certainly the legislature could have said that. It could have written that in if it meant to. California writes everything in, and they wrote that into their statute, that development agreements are referable. Or legislative, and so the legislature didn't do that here. And in terms of
can you proffer any other explanation for what the reference to the other section and the refusal to make them immediately or emergency powers?
Well, in terms of it wouldn't wouldn't allow for one to be an emergency.
But I mean, why would the legislature speak to that other than to avoid referability?
Certainly because some could be referable, right? I mean, as we've said, there could be provisions that would make a development agreement referable. But that doesn't mean that all development agreements are referable. In terms of the zoning statute, MU4, I mean, MU4 does give a very clear idea of what...
You're out of time, but I will ask,
Sorry.
since I told your opponent I was going to ask this question. So why does the city enter into a development agreement?
Well, here we've got some land that the city owns and some land that South Pier owns. If there wasn't a development agreement, South Pier could develop its properties, the city could develop or do whatever parks, et cetera, was going to do on its
But they
properties.
could contract for that, and you could enter into a contract for that that's just not a development agreement.
Right. Right, well, the development agreement allows for a conceptual idea, a conceptual plan as to what's going to be put on this property. I mean, the idea is that you don't want to
And it
have,
binds the city going forward?
and there is, I mean, the city says,
Does
you
it
know.
bind
to
the city
develop-
going forward?
To the agreement?
Yeah.
Yes. I mean, but there are, as you
Irrevocably.
pointed out, that there's future things that would happen, right? I mean, that the city doesn't necessarily have to enter into the GIPLET. The city doesn't necessarily have to sell the property. You know, developer intends to purchase, is what the ordinance says. Not that the developer is purchasing, is closing. That's not what this document is.
So you think that this is premature, that they should be filing the referendum when those giblets actually passed?
I'm not going to tell
Or
them
would
to
you
file a referendum.
So you wouldn't argue, no, your time was to do it back before?
Well, I think the time was to do it when there was the zoning, when there was the designation of this property.
You told me earlier that MU4 did not provide for the giblet, that these are future things.
Well, we've talked about two different things. MU4 was what was providing for the hotels, the office, et cetera. What is the public going to see on this property, right? I mean, if that's.
But you told me earlier it didn't provide for the giblet.
MU4 zoning doesn't say that property must be a GIPLET
Okay.
if it's zoned MU4.
Thank you.
Thank you.
Thank you, council, for the arguments. We'll take the matter under advisement, issue our decision in due course. With that, we are adjourned.